In our last video, we have already discussed regarding the state liability or the government's or administration's liability in tort, and in that connection, the very fault theory which is developed in French jurisprudence regarding the liability of administration in tort. So also in that context we have discussed the very role of council d'etat, which is the supreme administrative court and which has jurisdiction over all the civil and other courts in France. And in that connection also we discuss certain Indian aspects relating to state liability in tort. And in this video we will discuss certain constitutional provisions regarding liability of state and government or the administration in connection to contract. So, as per Article 294 of the Constitution of India, succession by the present government of the Union and any of the state or states to property or assets or rights or liabilities and obligations vested in the former governments. So also, Article 298 provides for the purpose of carrying out the function of the state government, so can they enter into contracts, and Article 299 contains essential formalities which a government contract must fulfill, and Article 300 provides the manner in which suits and proceedings against or by the government may be instituted. So, in regarding that, however, the constitutional code for public contract is not complete. Therefore, it is supplemented by the provisions of the Indian Contract Act 1872. A governmental contract to be valid, besides satisfying the requirements of Article 299, it must also fulfill the requirements of Section 10 of the Indian Contract Act dealing with the essentials of a valid contract. And in that connection, we would like to discuss a leading case, that is State of Assam versus Keshav Prasad Singh, and that is a case of 1953, and where it is decided in the same manner the principle for determining the quantum of damages contained in section 73, 74 and 75 are also applicable in case of government contracts. Also in Union of India and Natawar in 1963, it was held that the constitutional provision regarding contract must be carried out in their true spirit, and as regarding liability of administration as provided under section 298 to 99 of the Constitution. So, the very explanation regarding liability of the government in contract, it is an executive power of the president or governor executed on behalf of the president or governor, any person so authorized, and also in writing. So, in the leading case, Shakti Narayan Singh versus Arup Singh in 2004, it was decided grant by government contract must be published as advertisement in newspaper, having wide circulation as it was decided. So also in Vishnu Dayal versus State of Odisha in 2001, it was decided in any contravention of the provisions of Article 299 Clause 1 nullifies the contract and make them void, and Article 299 Clause 2 immunizes the president or governor or the portion person executing any contract on his behalf from any personal liability in respect of any contract executed for the purpose of the Constitution. So, in performance of the contract, any aggrieved person may sue the government for damages the government may sue or may be sued. So, in the leading case, Bihar EGF Corporative versus Sipai Singh in 1977, the Supreme Court held the following conditions must be fulfilled of a contract executed either by the union or state as it is a mandatory provision, and these are: the contract must be executed by a person so authorized by the president or the governor as the case may be. The contract must be by such person on behalf of the president or the governor. The contract must be expressed to be made by the president or governor as the case may be. In Ribat Hardo Singh versus State of Rajasthan in 1980, the court held that the court will not allow the government to harvest the benefits of not properly executed contracts. Also in Gujarat State Financial Corporation versus Lotus Hotel in 1980, the writ of mandamus can be issued against the government or its instrumentality for the enforcement of contractual obligation. So also in Perumal versus Union of India in 1951, it was held that the requirements laid down under Article 299, if are not complied with the contract, it will not be enforceable. So, also in Mulchan versus State of Madhya Pradesh in 1968, and also in State of Assam versus Keshav Pratap Singh in 1953, so also in State of Bihar versus Sonapti in 1954, it was held there seems to be not immunity from the consequences following under a contract and proceedings for its enforcement. The state is not immune. So, also in Davos government's factory versus state of Rajasthan, it was held in the same manner that in every contract, as per the very provision of Article 299, the state or the government are not immune from the very consequences following under a contract and proceedings for it enforcement. And in that connection, we'll discuss one doctrine, that is the doctrine of unjust enrichment, as it means that no person can get benefit when he has not suffered any loss. So, in the leading case, Fibrosa versus Fairbairn in 1943, Lord Wright also in Mulchan versus State of Madhya Pradesh in 1968, it was observed that in all civilized systems of law, proper remedy must be provided to prevent a person from getting unjust enrichment or unjust benefits. This principle of unjust enrichment is incorporated in Section 70 of Indian Contract Act 1872. The question as to relationship between Article 299 Clause 1 and Section 70 of the Indian Contract Act, as was explained by the Supreme Court in the very leading case, State of West Bengal versus B.K. Mandal in 1962, the very basis of liability, three conditions were to be fulfilled before this section could be invoked, and these are: a person should lawfully do something for another person or deliver something to him, and in doing so, he must not intend to act gratuitously, and the other person for whom something is done or to whom something is delivered must enjoy the benefit thereof. If the above conditions are satisfied, Section 70 imposes upon latter person the liable to make compensation to the farmer in respect of or to restore the thing done or delivered. And now we'll discuss the contractual liability and writ jurisdiction. Breach of contractual obligation on the part of state or its instrumentalities, wherein assurance or promise made by the state so the writ of mandamus can be issued for the enforcement of the contractual obligation. Constitutional and statutory obligations falls within the sphere of public law. So, as it was decided in Hespicial versus Dolidas in 1999 and Bini Limited versus B. Sadasivam in 2005, arbitrariness, absence of fair play, and breach of principle of natural justice, as the very contract would be held invalid and the state could be held liable for such arbitrariness or absence of fair play and the breach of principle of natural justice. So also in Mahabir Auto Stores versus Indian Oil Corporation in 1990, the nature of contractual rights, the manner, the method and motive of a decision of entering or not entering into a contract would be subject to judicial review on the very touchstone of relevance and reasonableness, fair play, equality, and non discrimination in the type of transaction and the statute of the dealings regarding such contract, and it was also decided in the same way in Sri Lanka Vidyavati versus State of UP in 1991. So also in Food Corporation of India versus ACIL Limited in 2008, it was held in the era of liberalization and globalization of economy, contractual disputes involving public law elements are amenable to writ jurisdiction. So, supply of sugar regarding that as it is an essential item, so it falls under Essential Commodities Act 1955. So the payment regarding that as it was withheld arbitrarily, so the writ petition was maintainable for securing the payment so withheld as it was decided in the Food Corporation of India versus ECIL Limited in 2008. So these are the very explanations regarding the contractual liability of the state or government or the administration as provided under Article 298, Article 299 and Article 300 of the Constitution of India. So, in that context, also we have discussed the very importance of Section 10 and Section 70 of the Indian Contract Act 1872. So also the very doctrine that developed by the apex court, and that is doctrine of enrichment, and that very doctrine of enrichment, how it explains the very unjust benefit derived or gained by a person. So these are all about the very concept of contractual liability of the state or government or its administration as provided in the Constitution of India.